This is part 3 to fishing for firearms in the Jordan. On April 9, 2008, Catherine Jordan, a firearms examiner for the Georgia Bureau of Investigation, gave testimony as to the weapon that was allegedly used by Roger Lee Baker Jr. that would frame him for the fatal blow to Calvin Ellison on July 7, 2007. It is imperative to note that none of the reports for the ballistics tests that Catherine Jordan stated she performed were available at trial, nor were they used as evidence for jury review. There was mention of cartridge cases, but only one was shown by the defense counsel. On page 129 of court testimony, John Wilson, the attorney for Roger Lee Baker Jr., is asked by Judge Bobby Peters if he wanted to show the court one of the bullets, to which he responded, "I think I've already showed them one of the casings, Your Honor." Why did John Wilson not just state that there had been no bullets found? And this statement confirmed in the fact that Judge Peters is asking to see one of the bullets because he hasn't comprehended that there were no bullets found at all. Catherine Jordan would attest to performing tests that, according to a communications record, weren't actually performed until after the conclusion of the trial. Therefore, it is logical to believe that she perjured herself on the stand to the state to say she performed tests she had not. None of these reports or tests were available or in the case file from trial at the Talbot County Courthouse or the state's exhibit list. The only way these reports are available is simply due to the fact that another Georgia Bureau of Investigation agent, Lee Brooks, performed an interview with Roger Lee Baker Jr. in January of 2013, to which he was informed that there were reports that Catherine Jordan had performed. We attempted to procure this interview. However, we were met with a shell game from the Open Records Unit of the GBI. Robin Gay stated that she wanted to charge us $150 for a redacted copy of an audio interview. I responded, "I also am not requesting redacted information." I then responded, "Unless this case is under seal or investigation, by law, I am entitled to unredacted organic copies. They are a matter of public record and are not part of the exclusion criteria according to OCGA 50-1872. Robin Gay then responded, "You are correct in that once a case is no longer pending investigation, prosecution, appeal, it is available under the Open Records Act. However, it is subject to redactions pursuant to Georgia law, including but not limited to OCGA 50-1872. I then responded, "Pursuant to OCGA 50-1871A, all public records shall be open for personal inspection and copying, except those which by order of a court of this state or by law are specifically exempted from disclosure. Records shall be maintained by agencies to the extent and in the manner required by Article 5 of this chapter. There is no court order to redact or withhold this information according to the statutory rule you cited, and therefore redactions to any public request for this specific information is a violation of the Open Records Act, and to attempt to charge me for documents you alter illegally is also a violation of OCGA 4511(1) A and B and 18 U.S.C. 641. I then received a response from Cheryl Payton stating, "The GBI Open Records Unit has responded appropriately and in accordance with statute. There may be records that by law are exempt from disclosure." I then contacted the Attorney General's office and they told me that they could not respond to my open records complaint because the GBI is one of their clients, but that I would contact Fred Mays. When I did, he told me to contact the staff attorney Laura McDonald. Why are they wanting to redact an audio interview that Roger Lee Baker had with Lee Brooks about what really happened to him and how he was framed? Why were they charging me so much for a redacted audio and then abusing the law to keep me from having it? And why was the Attorney General refusing to hold them accountable to the law even if the GBI was a client? And why were these people working so hard to cover up what has happened to Roger Lee Baker Jr., refusing to give him access to these documents that the GBI used to convict him, but never allowed the jury access to any of it? Was it because they knew that Roger Lee Baker Jr. was petitioning for a new trial based on newly discovered evidence? Stay tuned for part 4 to Fishing for Firearms in the Jordan.